In today's business landscape, customers demand the highest standard, and companies that fail to meet those standards risk falling behind and losing business. Welcome to Nexus Consultancy. We have dedicated over 15 years to helping businesses to implement ISO management systems for improved quality, compliance, operational excellence, and customer satisfaction. Our company's purpose is simple, which is to empower business and people. Our team of experts work closely with our customers to access their needs and create customized solutions that meet their specific requirements. We conduct thorough audits and evaluations to identify areas for improvement and help our customers implement changes that drive success. Our consultants have extensive experience and serve over 2,000 customers, and we stay up to date with the latest industry trends and best practices. Whether you're a small business just starting out or a large corporation looking to improve your operations, Nexus Consultancy is here to help you optimize your operations, increase profits, and achieve your business goals.
Good afternoon, everyone, and thank you for joining us today. So, can everyone hear me loud and clear? If let's say yes, can you type in the chat box so that I know you can hear me loud? Yes, thank you for your response. Yeah, thank you everyone for your response. So, welcome to the webinar OSH Legal Shakeout, What's New and What's Next. A timely and important session focused on amendment to Malaysia Occupational Safety and Health Act Amendment 2022, which officially came into effect on 1st June 2024. My name is Patience, and I will be your presenter for today's. As we all know, safety and health responsibility in the workplace has taken a dramatic turn with the recent legal amendment. But what exactly has changed? How do these changes affect your daily operation? And more importantly, what steps should you take to avoid non-compliance, penalty, or worse? So, over the next hour, we will be explore key changes in the amendment of OSH Act, actionable item steps that you can take to get audit ready and legally compliant. So, grab your notes, get comfortable, and feel free to drop your question in the chat box as we go. And let's get started. Because workplace safety is not just a policy, it is a legal obligation in 2025, is one we can't afford to ignore. Before we officially get started, I would like to know you in a little bit better, and I'm going to launch a poll. Don't worry, there are no right or wrong answer. It is just a fun way to understand your background and set the stage for today's session for the OSH Legal Amendment Act 2022. So, how familiar are you with the OSH Safety Health Amendment Act 2022? Okay, yeah, very good response from the crowd. Yeah, thank you so much for all your voting. So whether you are familiar, you are somewhat familiar, you are not familiar, today is a session for you where we will explore the key changes in the OSH Amendment Act. Okay, so before we dive into the details, here is some quick overview of what we will be covering in today's sessions. So we will start by setting the context before we talk about the OSH Amendment Act 2022 and why it matters. It is important to understand about how Malaysia legal system structure and where the Occupational Safety and Health Act fits in. And then we will cover the core in our webinar today, which is we will go through the major amendment from expanded scope and new duty to stricter penalty and structural reform. Also, we will discuss on how employer can begin to prepare internally with all these amendments. And to wrap up the sessions today, we will also look an actual workplace example to see how amendment law would apply in a practical setting. Okay, before we dive into OSH Amendment, let's take a first step back and understand the broader legal framework in Malaysia. Because how the law are created, enforced, and interpreted play a crucial role in compliance. So, in Malaysia legal system is structured into three main branches, and we call it LEJ, legislation, executive, and judiciary. So, for legislation is basically our law-making body. Their core function is to create and pass the law that impact to every sectors, including the occupational safety and health. And then the executive is what we call the implementations. So this include the Prime Minister and the Cabinet who manage the day-to-day governance of the country. They oversee the ministry, including the Ministry of Human Resource, which enforce the safety and health law through DOSH. And lastly, the judiciary. So these branches basically interpret the law through the court. If let's say there is any dispute about how the law apply, or if let's say someone is prosecuted under this act, so this is where it ends up. So basically, this is how the legal system in Malaysia structured. So now we have seen who make and enforce the law. So now let's break down the different type of legal instruments that affect the safety and health compliance in Malaysia. Think of this as a pyramid of authority. At the top, we have the Act. So this is a core law passed the Parliament, like the OSH Amendment Act 2022. So this Act actually set out the general duty and legal obligations. And beneath the Act, we will have the regulations. So this regulation normally is the details of the Act. For example, we have OSH Safety and Health Committee Regulation 1996. So this regulation actually outline how to set up your internal safety committee and run your internal safety committee. Okay, and then next we have orders. This order is a specific directive under the Act and regulation, such as notifications of accident or dangerous occurrence order 2004, which requiring the company to report certain incidents. Then we will have industrial code of practice. So for this industrial code of practice, they are non-binding but highly recommended document. Like for example, industrial code of practice for working at height 2018. So they show how to comply with the law in a practical way, tailored to specific risks. So this is basically showing the recommended best practice to comply with the law. Okay, and finally, at the base, we have the guideline. So the guideline is such as HIRAC, which stand for the high hazard identification, risk assessment, and risk control. So these are not a law. So guideline basically not a law. They actually provide a helpful tools to apply the best practice and stay on the right side of the compliance. So understanding this structure can help clarity which document you must follow and which one you demonstrate due diligence and also proactively safety culture. Okay. So for the OSH Amendment Act 2022, the aim is to establish a safer and healthier work environment for everyone. And here is some key objectives. So first, to protect the safety and health and the welfare of the workers from the risk of workplace. Other than that, the OSH Act also safeguard not just the employee, but also the visitor, the contractor, and others at the workplace. And lastly, to promote a culture of safety awareness and encourage effective OSH practice among all the workers. And these are some of the key regulations enforced under the OSH Act. And each of the regulations supports specific safety and health requirements across various workplace activity. For example, we have OSH Safety and Health Officer Regulations, and then the And then I would like to highlight, we will have 4 new regulations that has been recently added in line with the OSH Amendment Act 2022. These are official gazetted in 2024 and 2025. The new regulation you can see as I highlighted in blue colors, we have OSH Plant Requiring Certificate of Fitness Regulation 2024, OSH Licensed Person Orders 2024, and then we have OSH Construction Work Design and Management Regulation 2024. And also OSH Special Scheme of Inspection Regulation 2025. So these 4 regulation and order is the newly gazetted in 2020-24 and 2020-25, which align with the recent OSH amendments. Okay, so this update reflects Malaysia's shift toward to a more structured and risk-based self-regulated OSH framework. They also emphasize on the needs for the competent person and safe work design right from the planning stage. So here is a quick question for everyone. Okay, so who do you think is actually responsible for enforcing the Occupational Safety and Health Act and all its related regulation and order in Malaysia? Yes, very good. I see the answer from the group. Okay, so the answer is DOSH. Okay, very good. I saw a lot of people get it correct. Okay, so DOSH basically is a main enforcement agency under Ministry of Human Resource. So like I mentioned just now, the legal structure in Malaysia, we have the LEJ, Legislation, Executive, and Judiciary. So basically, DOSH is under the main enforcement agency under the Ministry of Human Resource. The Ministry of Human Resource is actually under the the executive, the legal framework under executive. Okay, so DOSH is the main enforcement agency under Ministry of Human Resource that responsible for ensuring workplace safety and health in Malaysia. They carry out the enforcement through several key methods, for example, approval and authorizations, registration, certification, inspection, investigation, and litigations. And where necessary, the litigation DOSH enforce laws such as Occupational Safety and Health Amendment Act, like the main topic we're going to discuss today, and also Petroleum Safety Measure Act 1984. Okay, so let's now move on to topic 2, where we look into the key changes introduced in OSH Amendment Act 2022. This amendment is the most significant update to Malaysia OSH framework since the original act was gazetted in 1994. It was driven by the needs to modernize safety law, close the existing legal gap, and align with the international standard. So here is some objective why amendment of OSHA come into the picture and repeal of the FMA. So I believe every one of you know FMA stands for Factory and Machinery Act. So why the amendment come into the picture? First is to introduce self-regulations to encourage employer to take greater ownership of OSH without always waiting for enforcement in actions. And also to allow development of new subsidiary legislation so that safety regulation can evolve with emerging technology and modern practices. And then, the most importantly is to eliminate the overlap between OSHA and the Factory Machinery Act, as both previously were covered similar ground, leading to confusion. Hence, with this amendment of OSHA, they are actually repeal the Factory and Machinery Act and put those that inside the Factory Machinery Act into this OSHA amendment. And then, another key objective for this amendment is also rectify the ILO convention, which align Malaysia with international labor standard on occupational safety and health, and to close loopholes in the OSH Act, basically making responsibility and penalty clearer, and finally strengthens the enforcement, giving DOSH better tools to ensure compliance and accountability. So in this webinar, I will highlight the 8 key changes in this OSHA Amendment Act 2022. So in the following slide, we will break down each of these changes, what they mean, and why they matter, and how your organization can respond proactively. First, the most significant amendment set out in this OSHA, which is this OSH Amendment Act will apply to all places of work throughout Malaysia, which including public service, statutory authority, and remote working if let's say the employee are work from home under the contract. So prior to the amendments, the law, which means prior to this amendment, right, the OSHA, the old OSHA is only applicable to specific industry like manufacturing, construction, wholesale, and retail trade. However, with this amendment, they mention apply to all places of work throughout Malaysia, except for domestic servant, armed force, and work on board ship. So domestic servant is basically like, for example, maid, housemaid, nanny, or child caregiver lah. Okay. And then the next key amendments is on the new duty on principal, employer, and self-employed person. So before we dive into what was the amendments, so let's take a look to have a better clarity on these three key parties, like who is principals, who is employer, and who is self-employed person. So a principals basically is any person of a company, is any person or a company who hire a contractors as part of their business activity, whether it's for trade, profession, or other work purpose lah. So basically, it's basically a principal engage a contractor or subcontractor or any agent to carry out the work for the business. Okay, so for example, who is the principal? So for example, a factory owner today hire a contractor to service the machinery. So in this case, the factory owner itself is basically the principals. Okay. And next one, employer. So employer, very straightforward. It's basically an employer is directly hire people under a contract of services and has a control over how's the work being done. So for example, so now I work for Nexus. So Nexus is my employer. Okay. And then lastly, we have the self-employed person. So self-employed person here refer to the individual who work for themselves and are not employed by others. Even though they are independent, they still have the duty to manage the safety for their own activity. Okay, so self-employed person we can understand as a freelancer. So for example, today your company, you want to hire a freelance welder to help you to do welding. So this freelance welder, they do not work for others, they work for themselves. So this is what we call self-employed person. So now, under this Amendment Act, all these three, principals, employer, and self-employed person have a clear OSH responsibility regardless of employment structure. Okay, so since we already understand, now take a look of the amendment. So under amended section 18A of the OSH Act, okay, principals are those who engage contractor or subcontractors. So now they are legally required to take necessary and practical steps to ensure the safety and health. Okay, so in that case, which means every principals who engage a contractor or subcontractors, okay, they need to take a necessary safety and health when this contractor or subcontractor work in their workplace. Okay, so what are the examples of safety and health measure that this principal can take? So, for example, when those subcontractor or contractor, they are working in the principal place. So what principals can do? Principal can conduct a site safety briefing before starting of the work to ensure all the contractor and subcontractor understand the hazard and emergency procedure and the site rules. Other than that, principals also can conduct a joint risk assessment and issue permit to work for those high-risk activity, for example, working at height, confined space, hot work. And also what a principal can do is provide a clear access and safety signage. So these are some of the examples of the safety measure that a principal can take when subcontractor or contractor working at their workplace. Next, about Section 18B. So this Section 18B, which apply to principals, employer, and self-employed person. So under this section, it is now mandatory for them within these three parties to conduct a risk assessment on safety and health hazard at the workplace. After carrying out this risk assessment, it is mandatory to implement appropriate risk control measure based on the assessment finding. So often got people ask, so what does this risk assessment refer to? So this risk assessment actually refer to establish a process known as HIRAC, which is Hazard Identification, Risk Assessment, and Risk Control. There is a guideline published by DOSH. So all the employer, self-employed person, or principals, they are required to carry out this risk assessment in relation to safety and health risk at their workplace and implement the control. So this amendment reinforced the safety, no longer just a tick box exercise. It is a shared responsibility and across all the parties at the workplace, regardless today you are an employer, a principal, or working for yourself. Okay? So before I move on to the next slide, so can I have a quick pause to ask about these questions? So which party do you think is legally responsible for ensuring workplace safety under OSH Act? Okay. Okay, very good response from the crowd. So yes, the answer is all parties involving principal, employer, and self-employed person. Next, move on to the next slide. So next amendment is on Section 26A. So this new provision grant the employee the statutory right to remove themselves from imminent dangers at work and provide the protection to the employee exercising such right from undue consequences and discrimination. However, such right is subjected to the condition that the employer has been duly informed of reasonable justification of the imminent danger but failed to take any action to remove the danger. This Section 26A is mentioned the right of employee. So right now with this OSH Amendment Act, there is a right of employee, which means as an employee, I have the right to remove myself from the danger of work. Let's say I already informed this danger of work to my employer and my employer failed to take any action. Then in that case, I have the right to remove myself from this work. Okay, and when I remove myself from this work, I shall be protected, which means I shall not be discriminated, with my actions. Okay, so this is with the new amendment, right of employee. So the imminent dangers here refer to a serious risk of death or a serious body injury to any person that caused by any machinery, any chemicals, any work practice procedure, or any workplace hazard. Okay, so these provisions accord better protections to employees from dangers and prevent any fears of repercussions for the employee to exercise such right. Okay, next one. The fourth amendment, the fourth key amendment is on notification of occupational of place of work installation and inspection of plant. So under Section 27A, all workplaces are required to notify DOSH upon occupying a place of work, except for those already exempted in the first schedule of the Act, which I mentioned earlier, domestic servant, armed force, and work on ship. Okay, so right now, the notification to the DOSH is through my KKP system. So which means all the notification you must submit through this my KKP system. And periodic factory inspection is abolished already. So no longer practice already. Okay, so this is shifting towards a more proactive and self-managed compliant models with this amendment. And next one of the major changes under this OSH Amendment is the repeal of Factory Machinery Act, like I mentioned earlier. The FMA has been repealed. Okay, so with this repeal, the requirement in the previous FMA have now fully transferred and updated under OSH Amendment Act 2022. So under Section 27B to 27E, okay, employer now must ensure the following type of plant. So plant means machinery, like boiler, pressure vessel, lifting machine that required certificate of fitness, which is CF, like PMA and PMT. Okay, and then all the inspection need to conduct by a licensed person approved by the DOSH. Okay, and basically all these updated requirements are now clearly outlined in the Occupational Safety and Health Plan requiring Certificate of Fitness Regulation 2024. So with the repeal of FMA now come into this new regulation, so all the machinery like boiler, pressure vessel, and lifting machines, all the requirements of inspection or the license has been set out in these new regulations. Okay, so this new regulation provide a better clarity and enforcement under the OSH Amendment Act. Okay, and then the second amendments under this notification occupational of place of work installation and inspection of plant, which is on new introduction of Section 27F, which outline the special scheme of inspections. Okay, so for this special scheme of inspection is designated for plant requiring certificate of fitness, like I mentioned just now, like boiler, pressure vessel, and lifting machinery. So under this SSI, the CF can valid up to 60 months, okay, compared to the typical 15 months of validity. And for this one, under this SSI, the inspection no longer carried out by DOSH or any licensed person that approved by DOSH. But instead, this inspection is carried out by the occupied own risk-based inspection team. Okay, so this is also one of the self-regulation models governed by the Occupational Safety and Health Special Scheme of Inspection Regulation 2025. So who this applicable to? So typically this applicable to, like, for example, oil and gas industry, and to qualify, the occupied must make the application to the DOSH. And DOSH is the one who subject whether want to approve your application or not, whether you fulfill the requirement as mentioned in this special scheme of inspection regulation 2025. Okay, so this shift from the enforcement-based compliant to accountable self-regulation, rewarding the company with a strong safety culture. So the next amendment is on the appointment of OSH Coordinator, which is under Section 29A. So with this amendment, right now, employer has 5 or more employees at a workplace. The keyword is at a workplace that are not listed under the SHO order right now. They are now required to appoint one of their employees as OSH Coordinator. Okay, in another word, OSH-C lah. So basically, this role of OSH-C is to assist the employer in coordinating OSH compliance and also program to ensure safety and health measures are implemented effectively. Okay, so if let's say today, the employer had already appointed a qualified SHO, which is Safety and Health Officer, even though it is not required, because not every industry requires Safety and Health Officer. Only certain industrial that listed in the order, like for example, construction project more than 20 million, or maybe your manufacturing environment have more than 500 workers, or maybe today your industry involved in metal fabrication, you are required to have SHO. So if let's say your factory already or your place already got a SHO, in this case, you no need to appoint a OSH-C. Okay, so this is basically under this amendment. Okay, so this amendment also ensures that even smaller or lower risk of workplace maintain a active OSH management. Another important additions on the OSH amendments is on Section 31A, which introduced the mandatory OSH safety and health training for certain individuals. These sections allow authority to require specific class or specific category of people or workers to undergo prescribed OSH training, especially those involved in higher risk and critical operations. So, the objective for this is to ensure that this individual receive adequate exposure of the safety principles and have the right knowledge before performing any work related to their task. Okay? So this proactive approach also helps to prevent incident caused by lack of safety awareness or untrained personnel. So, an official order will be issued under this section to define exactly who must attend and what type of training apply. Okay, and these changes support a safer and more competent workforce across all the industry, particularly where hazards are present. Okay, under Section 31B, formalize the requirement that certain OSH activity must carry out only by certified competent person and registered training provider. So these are also another new amendment in OSH Amendment Act, which is 31B. So this one is talking about we need to ensure only qualified individuals handle critical safety tasks and only accredited training providers are allowed to deliver OSH-related training. So it is a move to raise the overall OSH implementation across the industry. So to strengthen this Section 31B, the fifth schedule of the Act clearly defines what are the type of activity that can only be carried out by registered competent person. Okay, so for example, to conduct a health risk assessment for any chemical that is hazardous to health. So which means the one who conduct the CHRA in your factory, it needs to be a competent person. Okay. So these provisions ensure that only qualified, trained, and certified professionals are entrusted with critical OSH role, helping to maintain a high standard of safety and technical integrity. And lastly, the OSH Amendment Act 2022 also introduced a much stricter penalty to reinforce compliance and improve workplace safety accountability. So one of the very obvious in this amendment is basically the penalty. So the penalty has been increased. So for example, I mentioned just now, under Section 29A, the OSH Coordinator. So if let's say today the organization failed to appoint the OSH Coordinator at one workplace, so the penalty can up to 50,000 or in prison of 6 months or both. Okay? Okay, so this is basically one of the key penalty. So these changes send a strong message that workplace safety is no longer negotiable. Okay, employer, contractor, key personnel must act responsibly or face a heavier legal consequences. Okay. Now that we have walked through the key amendments to this OSH Act, we have highlighted 8 key amendments. So let's talk about what actually means for you on the ground, and the legal changes are already in effect and enforcement already begin. So it is not just knowing about the law right now. It is about taking a clear and proactive actions. So what's next? Turning a legal risk into actions. So as I mentioned, the OSH Amendment 2022 is already in effect. So here is what the employer can do to protect their people. First, we can conduct a post-amendment compliant gap audit. Start by assessing where your organization currently stands. Okay, for example, are the OSH responsibility clearly assigned? Has you appointed any OSH coordinator? Is your hierarchy up to date, or is there any risk assessment you have carried out? related to the safety and health risk in your workplace. So this audit will help you to identify the blind spot before DOSH does. Okay, after you conduct the audit, so next, use what you find in the audit to update your SOP, to update your internal policy. Okay, for example, do you have a written policy for an employee right to refuse unsafe work under Section 26A? So like I mentioned just now, right of employee. So do you have any policy or not? Like for example, when the employee report, this is an imminent danger. So how do you react to it as an employer? So do you have such policy in place? Or is this being informed to the employee, informed to all the employee, this is their right? Okay, this is the things that we can start doing it. Okay, or for example, do your contractor engagement procedure reflect the new duty under Section 18A or not? So like I mentioned just now, under Section 18A, the principals have the responsibility to ensure safety and health measure is in place when contractor or subcontractor in the workplace. Okay, so these documents must reflect today's legal reality lah. So after you update all the SOP and the internals policy, next, it's time to launch a internals OSH awareness campaign. This isn't just a management issue. Everyone in the company, from site workers to the supervisor, need to know what is the new law means to them and how it affects their operations. Okay, so you can run a toolbox meeting, send internal bulletin, create some visual reminder, create some HSE campaign, health and safety or OSH campaign to actually raise the awareness of people. And lastly, train your line manager and supervisor. Okay, your frontliner, especially your supervisor, okay, they need a targeted training because they are often the first point of contact when something goes wrong. So make sure they know how to respond, escalate the issue, and fulfill their new legal responsibility. In short, compliance not just one-time task, it is a continuous process. Align your people's policy and practices with the law. And these 4 actions are the foundations. And let's move from legal risk to confident leadership. All right, we have covered the legal update. We have gone through the action to take. Now is the time to bring it all to life. We are going to work through a real-world scenario, something that could happen in your company or your organization right now. And I want you to think, what would you do if this was in my workplace? Here is the first scenario. Company B with 10 employees operating in a logistic warehouse failed to appoint an OSH-C, assuming it is only for high-risk industry. So now here is my question for all of you. Feel free to drop your answer in the chat box if you are joining us online, or you can shout out if let's say you are here in person. Okay, so you may think, what's wrong with his assumption? Or maybe what is the risk not appointing OSH-C? Okay, and anyone feel free to type your answers. So is this correct or not? The company only have 10 employees and then they fail to appoint an OSH-C and assume it is only for high-risk industry. So is this assumption correct or wrong? Wrong. Okay, thank you for your answer. Okay, so let's see the implication. Okay, so correct, the assumption is wrong. So under OSH Amendment Act 2022, any workplace that not under the SHO order but more than 5 employees must appoint OSH-C. If let's say the failures to comply, this will lead to 50,000 fine and also imprison 6 months or both. Okay, so very good, everyone. Okay, next one, we have another question, another scenario. Okay, a worker noticed that an unstable scaffold and he report it. No action is taken, so he decided to leave the site. Now, what do you think? Can he legally do that? Is this abandonment of the duty, or is it a misconduct? Anyone? He has no wrong. He can leave. Yes, correct. Very good. Okay. So everyone got it correct. So yes, the right of employee under section 26A. So the employee have the legal right to remove themselves from the imminent danger after notifying the employer. The keyword is after notifying the employer, and the employer did not take any action. Then in that case, they have the right to remove themselves from this imminent danger. Okay. And also the workers shall protected from any disciplinary action or dismissal for doing so. So he shall not get discrimination after he do so. Okay? Yeah, thank you everyone for your actively participate in the scenarios sessions. Okay, so thank you all for staying with us throughout the session today. So we have covered the major changes and appreciate your participation today. And now we would like to hear from you. So I saw few questions in the chat box, so I will pick some and also dive into your questions. Okay, let me go through. Okay, for this term, can you help to explain for normal industry, as example, manufacturing that have CF for PMA, do SHO need to do inspection? Okay, so basically, for normal industry, for example, manufacturing that you have those lifting machine, or maybe, for example, you have lifting machine, or maybe you have some pressure vessel that required the CF1, PMA or PMT. So do SHO need to do the inspection or not? Okay, yes, SHO have the responsibility, but it may not be the technical inspection for the CF renewal. Okay, so which means you have the responsibility to ensure this CF is renewed. And also you have the responsibility to ensure this machinery is working in the good conditions. Okay, so this is basically your responsibility. However, it's not the technical inspection like you renew the CF, like you engage DOSH or licensed person come to renew the CF. Okay, and then am I answer your questions? Okay. I have another question. Since FMA Act is repealed, it is enough to cover all the law in OSH new amendment. So yes, currently there is like I mentioned, there's two new regulation coming out, which is plant requiring certificate of fitness. So the one is actually cover the machinery that require CF. So the one is mentioned in the regulations, and also the special scheme of inspections. Yeah. So next one is OSH-C competency is valid for how long do they need to renew it? So the answer is OSH-C do not have expiry date. Okay, so no need to renew it. Is the new act already enforced? Yes, already enforced since last year, 1st of June, starting. Does the new publication reference book for this OSH amendment has released to the market? Yes, it is. So you can now purchase in Popular the book. Yeah. Okay, what are the two regulations coming? So, like I mentioned in my slide just now, Occupational Safety and Health Plant Requiring Certificate of Fitness Regulation 2024, and also Occupational Safety and Health Special Scheme of Inspection Regulation 2025. I will type this in my group chat for your reference. Okay, I will type in my group chat. Okay, and then if we have 4 factories, how many OSH-C or SHO we need? Okay, so first, just now the under section 29A is talking about workplace. So you have 4 factories, which means you have 4 workplace. So first thing first, you need to see, does your factory fall under the safety and health office official order, the one, which means manufacturing more than 500 people. Is there fall under the one? Or today you are metal fabrication factory, or maybe your project more than 20 million. So there are few lah, okay? So if let's say today your factory does not fall under that category that require SHO, then in this case, you need to appoint 4 OSH coordinator. Because if let's say you are not fall under the SHO order, then in this case, you just need to appoint OSH coordinator. And under the section of the Act is mentioned workplace. So workplace, which means at the place of work itself, you need 1 OSH coordinator. So if let's say you have 4 factory, then you need to have 4 OSH coordinator. If let's say your factory is not fall under the category of the SHO order, okay? If let's say your factory is fall under the SHO order, then in this case, you need to have 4 safety and health officer. If let's say in that case, you no need to have OSH-C. Because when you have the safety and health officer, you no need to have OSH-C already. Okay, so our company do not engage the ISO 18001 or 45001. So how we going to start as we only engage FSC 22000 as these two ISO are different. Okay, so like I mentioned just now, you can actually start to conduct the gap analysis to see like how far is your company with the OSH Amendment Act, and also the gap analysis with this 45001. Like the 45001 requirement, what are the gap that you need to fulfill? And then after that, carry out accordingly. So in the end of this webinar section, we also got offer a ISO 45001 checklist for you to have a quick gap. Identify your quick gap, in your ISO 45001. Okay. Okay, and then if 2 companies, same boss, sharing the same premises, each company more than 5%, can we appoint same OSH-C for these 2 companies? Okay, so the answer is, okay, 1 OSH-C will do. No need to have 2 because we are talking about workplace. Okay, is there any questions from the floor? Yes, you can put OSH-C in your safety committee chart. So for example, in your safety committee chart, right, normally the SHO will be the secretary. So if let's say your company do not have SHO, then in this case, the OSH-C can act as you can appoint the OSH-C as a secretary. Does work from home risk and hazard need to be documented under HIRAC under this new amendment? The answer is yes. Okay, so the answer is yes, because I mentioned just now earlier, the expansion of scope is all workplace. So work from home is under one of the scope. That's why we need to carry out the risk assessment as well. The basic risk assessment on the work from home workplace. Does the HQ need to have their own OSH-C? Basically, it's workplace. We refer to the workplace. So basically, all the workplace need to have OSH-C if let's say the workplace itself has the employee more than 5 people. Okay, so I think I answer most of the question. So thank you for your time today. So before we wrap up, we have got something that could make all of the difference, a tools that to help you to spot the OSH gap before the auditor do. So it is a free ISO 45000 scorecard, a 2-minute checklist that reveal if your workplace is truly audit ready or silently at risk, quick to use and free for the verified webinar participant until 29th of May 2025. So you just scan the QR code and fill in the short form and your download will be ready right after. And if let's say you need any support with setting up the OSH management system or navigating the latest legal changes, we are ready when you are. So just now, one of the participants asked me a question about if let's say I want to set up the ISO 45000 and I don't have consultant, so what should I do? Because your company only have FSC 22000. So you can try to download this checklist, a quick 2-minute checklist to see where is your gap. However, you need a thorough gap analysis, then you need to base on the OSH Amendment Act and also the ISO 45001 standard book to see where is your gap, and you need to start establishing the SOP or the policy based on the gap. Okay, or you can speak with us. We are ready to help if there is any. Okay. And second, your next step forward. So we are inviting you to join us live on 18 June, 2 p.m. for Building a Strong Food Safety and Quality Culture, a session designed for food industry leaders who want to move beyond SOP and build a real measurable culture. The speaker is Chloe Chan, an experienced consultant and a HRD Corp certified trainer. So this session is packed with practical strategy, FSC 22,000 insight, and real industry example you can act on. So if you are ready to turn your food safety into a team-driven habit, not just a policy, save your seat today and invite your team to join us. Okay? Thank you everyone for joining me today.